I am left with no option but to commit Mr. Zuma to imprisonment with the hope that doing so sends an unequivocal message. In this, our constitutional dispensation, the rule of law and the administration of justice prevails.
In June 2021, former President Jacob Zuma was given a sentence of 15 months imprisonment by the Constitutional Court for contempt of court after defying its order that he appear before the Zondo Commission. The granting of medical parole, subsequent court action that invalidated it, and the granting of a special remission of sentence led to Zuma effectively being a free man after serving 3 months in custody. A couple of years later, he would be central in the formation of uMkhonto weSizwe Party to the extent that he was ranked number 1 on the party's candidate list. His 15-month sentence would rear its head again and lead to the disqualification of his candidature following objections due to his sentence.
That prison sentence started in July of 2021 and ended in October of 2022. And that, because it only ended in 2022, he is disqualified for the next 5 years. So he can only become a member of parliament after the 5 years is up, which is about 2028 or 2027.
Zuma, however, would successfully challenge the disqualification of his candidature based on Section 47, subsection 1E of the Constitution in the Electoral Court. The Electoral Court would rule in his favor, finding, among other things, that the section in question did not apply to the former president because his sentence was not appealable. The Specialist Court noted that the drafters of the Constitution recognized the fact that a person convicted and sentenced has a right to appeal against a conviction and sentence, and ultimately found that the Commission erred when it upheld an objection against Zuma based on this section. This prompted the IEC to turn to the Constitutional Court for clarity on the section before elections.
The outcome or in terms of the order of the court leaves a number of constitutional questions, and once there are constitutional questions, it's the apex court, which is the constitutional court, that must give the clarity, the understanding that is desirable.
The Council for the Advancement of the South African Constitution has been admitted as a friend of the court and seeks to assist the court in determining the matter by centering its submissions on the separation of powers principle and the nature of the president's power to remit sentences.
We believe that the separation of powers clearly would require that the sentence imposed by the court must be respected at all times, that the effect of an executive decision, whether by a parole board or by the president, in this case, for the purposes of reducing overcrowding in prison, simply means that the term of the sentence is reduced by executive decision, but it has no impact on the initial sentence. And particularly in the context of Section 47 of the Constitution, we believe that the Constitution rightly places that responsibility in terms of the length of service to exhibit and demonstrate its dismay with the kind of conduct that would demand a sentence of more than 12 months, that should be a judicial function.
The Apex Court will hear the matter on Friday, which will bring finality to the question of whether Section 47, subsection 1E, applies to the former president before any votes are cast. Kani Mapanga, SABC News, Johannesburg.